us. We'll give everyone a couple minutes to get situated. But again, we're grateful for you carving out some time on this Wednesday morning as we lead up to the 4th of July holiday. So again, if you can just bear with us for a moment or two, we'll get everybody ready to dive into estate planning.
Everyone's favorite topic.
Yes, yes. I tried to allude to that in the intro or the invite.
All right, so we can give it one more minute here as people are filtering in.
As we were talking about, Matt, it's funny because I'm reflecting on the meeting we had with Daniel Crosby last month, which was generally well received. And my joke was like every time we have one of these webinars, the gods are not with us with respect to the weather. So on Saturday, I'm like, oh, we're good for this one. We have a torrential downpour and electrical storms.
Not
And
today.
sure enough, as I look outside, 75 and sunny. So probably a couple people snuck out to the beach or playing hooky. But for those who are joining us again, we do appreciate the time. We'd like to think that this will be an engaging experience, right? Like I've got this view of making sure that wellness is not just something about portfolio management. So we'll take some time here with you, probably an hour or so, to really get into the subject matter. So without further ado, let me introduce our esteemed guests. Right, we've got two experts, folks who have been in the field and really can bring a lot to the discussion. So let me first introduce Peggy Nee. Peggy is a Jesuit like I am, a Fordham grad, where she went to undergrad and law school, and then has a master's in taxation. She's right up the street in Hackensack, New Jersey. Her field of expertise within the subset of estate planning is also elder care planning. So we're going to spend some time on that. Peggy and I have some mutual clients, and so again, really excited to have Peggy join us. Alex Curvin has joined us from Colorado, right up the street from Maddie. We'll give him a lot of credit for some of the content today and his technical expertise. In reviewing his bio, I almost wanted to take a few minutes to carve out some time and discussing what's going on in Russia. He studied Russia in undergrad at Indiana University before pursuing his law degree in Boulder. So again, Alex works for a larger firm in Colorado where they focus on a host of different fields of expertise, but his swim lane is estate planning. So thank you both for joining us today. Again, we really have a full packed agenda, and we're excited to get into the particulars. Maddie, I'll have you just kind of take us through the actual agenda for today.
Yeah, so we know that, as Jeff said, wellness definitely encompasses a lot of different topics. We feel that estate planning is one of those topics to take a look at closer from, a critical standpoint to prepare for yourself and your family and your loved ones and make sure that your assets are passed, as you see fit and as you want. So today we're going to be covering sort of the basics of estate planning. We had sent a few articles on that, for preparing for this webinar this month. Then we're going to be getting into elder care, more sophisticated planning strategies, including revocable trusts, more complex trusts. Then we're going to be getting into, what people want to know about in terms of the sunsetting laws, possibly coming in 2025 and different ways to approach that time. We're also going to be talking about some different strategies for blended families or whose families may plan separately from one another, from partner to partner. And then ending with some final thoughts. And certainly we want to open it up for questions for our audience to ask our esteemed guests here. So without further ado, I'm going to share my screen. We have a PowerPoint presentation to share because we're going to be having a really meaty discussion today. So 1 second.
That's great. And folks, just along those lines, we oftentimes get requests for content. This is a recorded event, so you'll probably within a week's time get another email from us which has both the entire meeting, but ultimately the slides as well. So again, thanks for letting us take you through this. So I think what I'll do in terms of like kicking off is just ask Peggy to maybe just take us through the basic part of estate planning or the kind of key elements that are critically important when you sit down and engage a client for the first time, or someone who says, "Hey, I don't even know where to start." So can you just kind of spend a few minutes with us on the fundamentals?
Sure. Thanks, Jeff. And thank you again to Alex for putting together these great PowerPoint slides. One of the things I will tell you is that I guess you could call it a very slight side benefit of the pandemic was there became a very intense focus on estate planning, but not really it's not really espoused in that manner. It was more people realizing that they might be facing an end that they never anticipated. And they started thinking about things like, oh, wow, I don't have a healthcare directive. I don't have I don't have power of attorney. What if I go to the hospital? What if something really bad happens? I don't even have a will. So I can tell you, we were hit very hard here in the beginning of the pandemic, and there was a lot of emergency work being done to help people. So with that being said, what you see on your screen are really the basics. I don't care if you have 5 cents or $50 million. These are all documents that pertain to you. And if not to you, if you have perhaps adult children, or any loved one who you know is over 18, they all should be thinking about these documents. So your will, it's referred to as a last will and testament for a reason. So it is whatever will you end up with right before you die. If that's your will, that's the last will, and that is what is going to govern distribution of your assets. So a lot of people say to me, I don't have any money. What do I care? I don't need a will. Well, one thing is you don't know what you're going to have when you die. You don't know when you're going to die. And if I knew that, there would be people lined up around the block to see me. And the other thing is that if you do not have a will and there is something to distribute from your estate, could even be a settlement of a personal injury case or a wrongful death case, it will be distributed in accordance with your state's law. And there's a distribution scheme, there's a statute, and it will say, here are the people who take in the event this person dies. Now, when you start reviewing who those people are, it could be your spouse, but it may not be all to your spouse. It might be partially to your spouse and to your children, partially to your spouse and your parents. Because that is one of our intestacy provisions in New Jersey, is if a person dies, they're married, they have no descendants, but their parents are living. Guess what? Parents are in the distribution scheme. It could be, you say, well, I don't have a spouse, I don't have parents, I don't have children. What do I care? Well, your assets will go to your siblings, or maybe to the descendants of your siblings. Or you say, I have no siblings, I have no nieces and nephews. Then we start going over to aunts and uncles and cousins. And I don't know about you guys, but I have an awful lot of cousins, and there are an awful lot of cousins that I haven't seen in a long time. So, it goes out and out and out. Now, a lot of people will say to me, oh my gosh, it's going to go to the state. Oh, we don't want the state of New Jersey receiving assets. Well, it takes a lot before it gets to that point. You really have to have no either we say direct descendants, collateral relatives. So when you sit here and you think about it, and I'm saying these things, I'm hoping you're saying to yourself, I'd rather control who's receiving my hard-earned estate rather than some state dictating where it goes. So again, very important to have a will. Anybody, by the way, over the age of 18 should have a will, not just people who are getting up in years. Power of attorney.
Sorry.
Super important power of attorney. This is for when you are alive, and you are basically designating someone as your agent to act on your behalf and take care of the things you can't take care of. And it could be something as simple as you're in the hospital, you can't get to a bank, you can't call a credit, some kind of a bill that you owe on the phone, you can't get in touch with them. The person who's power of attorney, you've given them authority to act. It is a contractual relationship, but it's also a fiduciary relationship. Contractual in the sense that if you change your mind and say, wow, I made a mistake designating this person, you can revoke the power of attorney. There's no irrevocable power of attorney, at least in most states. Very important. If you do not have power of attorney in place and things have to be done on your behalf, financial matters, there is going to be a guardianship proceeding for you. You don't want that. That is not a good thing. We can get into that at another time, but this is not positive. So think about power of attorney, the right people to choose, etc. Healthcare proxy, medical power of attorney, super important. Super important, if I can't say it enough. Why? Because you need someone, if you can't control your medical decisions because you are so ill, you can't do it, or you're unconscious, you want to designate a person to make those decisions for you, to be your representative and advocate in a healthcare setting. If you do not do that, these decisions will be left to the facility where you are located. And that is not something, these are busy places. They don't have a lot of time to focus on your past medical history. What should happen? Should we give this person a feeding tube? Should we give them life-sustaining treatment? They're not going to focus on it the way someone you designate is going to focus on it. So we really urge you to look at that. Every state has little variations on their healthcare proxy law, but what we find is they're all kind of merging together, becoming more similar. So, but I would say, please look at that. Living will, we all have different terms for living wills. That's the original term that was used before there were statutes. Some states will call it advanced medical directive or a healthcare directive. It's in a statement of your intention as to what you would like to have happen if you are in a, let's say, in a persistent vegetative state, or you are, you have a certain degree in terms of how long will you live? Is it less than 6 months? You will set forth protocols for what you want to have happen. While we encourage people to have a living will, we're maybe more focused sometimes now on the healthcare directive or the healthcare proxy portion. Sometimes it's a separate document, it's the same document, but the idea is really important to have a spokesperson, really important. Trust. Some people need a trust, some people don't. Why do I say that? Well, I happen to be in a state where probate is the only positive thing in the state in terms of the government and how to handle it. Why? We make our probate system extremely simple, very user-friendly, no notice, pre-notice provisions before probate, no disclosure of assets required. If your estate is $1 or $100 million, the fee is the same. So we're a friendly probate state, but not every state is. Some states, it's a huge court proceeding, a lot of disclosure involved. So why would somebody have a trust? Because they want to avoid probate, or they have assets in real estate in different states. Because every state where you own a piece of real estate, there's another probate required. We call it ancillary probate. So trust, a revocable trust or a living trust can be very important in your plan. Some people create trusts that are more for either asset preservation, gift tax, part of an estate giving program, or Medicaid issues, wanting to preserve assets to eventually be able to avail themselves of Medicaid assistance. So lots of different trusts, lots of situations where you may need them, situations where you don't. Look at your beneficiary designations, very important. People sometimes will fill out a beneficiary designation form when they begin on a job. This happened, by the way, at 9/11. We had a lot of issues with this. I did a lot of work for families. We had pro bono programs, and we were trying to help families. Well, I had one case where the person was killed in the 9/11 disaster, and they pulled open, he had a family, he had a wife, he had children. They opened the beneficiary designation of his work-related insurance, life insurance, and his mother is the beneficiary. And, that can cause a lot of ancillary problems. Some situations, and I had that, and by the way, it wasn't just myself or other colleagues. Some of the mothers would just say, here's the money, I understand it was never changed. We had situations where people didn't like each other so much, and that didn't happen. We had situations where the mother or the father were in a nursing home and were on Medicaid. So it's very important to look at your beneficiary designations from time to time, make sure they're up to snuff, that they reflect your current intention. Guardianship designations, that would really pertain in most states to guardians. Who's going to be the guardian for your minor children? Very important. That person basically steps into your shoes as a parent, and will be determining all legal matters with respect to that child. Where are they going to live? Where are they going to go to school? Medical care, all kinds of issues. So you want to have one reason for a couple who may say to me, I have no money, what do I need a will for? Well, you have children, you want to designate those guardians. You don't want a court coming in and determining based on they have this best interest standard and everything, but it's still something that could go awry, because you might have people who are pushing to have the children, the guardianship and custody of the children, that may not be the ones you would have chosen, for whatever reason. It could be where they live, their, the way they relate to the children, or the way they related to you. So very important to designate guardians. Letters of instruction, those could be, they range from all over the place. So they could be letters of instruction on disposition of assets, like personal property. In New Jersey, you can designate tangibles like your jewelry, your knickknacks, your heirlooms. You can actually fill a letter out of instructions to be referenced in your will, so that you can pass those different things on to people without constantly updating your will. Your letter of instructions could be as to your children. Details like, what do they do? What are their interests? Should they go to camp? Should they, what kinds of programs are they involved in? Religious instruction. So all these things are really, things you would put together. You'd have like a nice, if you could put it together and you're organized, you have a nice binder with these in, or you might have a file, whatever it is, but it makes life easier for your loved ones.
Thanks, Becky. That's great.
All right.
Let me hit on, like, it's an interesting topic. So Maddie and I spend so much of our time talking with clients about like the kind of wealth transference element of estate planning, largely because we're thinking about tax minimization. But the field of elder care planning, which does fall into this category of estate planning, is really a kind of a unique subset. And so we'd love to just have you kind of give us a better definition that I'm able to come up with of like what makes elder care planning different from general estate planning, and then why is it so important?
Well, Jeff, it's elder care planning. The very interesting thing about elder care planning is it didn't exist when I got out of law school. I mean, I know I don't look like a youth here, but I didn't get out that long ago. But 40 years ago, this wasn't a topic. This wasn't an area of practice. I mean, why? For a couple of really the primary reason, people didn't live to be that old. The average, if you looked at life expectancies, much lower on the tables. People, I mean, most people would have, unfortunately, go by grandparents. Grandparents were dying 50s, 60s, 70s, mainly heart-related issues. We didn't know, for example, very few people knew we didn't even know what Alzheimer's disease was. It was a very, it was just starting to get out there what that term was. Dementia, people thought, it was just somebody who they called senility. But I can, just to share one fact about myself, my grandfather, I have one grandfather who lived to be 95, very disabled. When I told people he died when I was 10, okay, so he was a lot older than me. When I told people my grandfather died, he was 95, they were like astonished. Did somebody live that long? It was just unheard of. Today, that's nothing. I mean, we have people over 100. So what happens? You get older, and unless you're really super lucky, things start not working. If it's not the brain, it's the body. It could be that there are a myriad of neurological issues and diseases that can really severely impact your activities, what we call activities of daily living. And what happened was, this started arising. This became more of an issue, I would say late 70s, early 1980s, and became an area of practice and an area of concentration, and a whole industry has emerged in terms of elder planning. It's very difficult. It's very weird in the sense of, when you discuss the planning concepts, they are not the norm. You tell someone to do something in terms of elder care planning, and with assets in particular, and they'll say, that makes no sense to me. That's odd. I don't understand. And a lot of it has to do with the benefit programs that are available, and the fact that it's all means tested, and you literally have to have little or no assets in your name. So some of the planning techniques are just completely different than what you would expect to hear. And, even 15 years ago, there was sort of the focus was, I don't have to worry about this. I'm worth, let's say, $3 million or higher. And this is not a concern of mine, but with the inflation adjustments in terms of cost of care, they are not the normal numbers you see today. We're all worried about inflation. The cost of care has gone up exponentially on an annual basis for quite some time, whether it's facility like skilled nursing facilities, assisted living, home care. Home care is super expensive. So you have to focus on it, and you need to think about it. And last part of that would be to the answer is long-term care insurance. Great product, but the market has shrank, very hard to get. Very few people can qualify for it, and very few people can afford it. It is expensive. So that component, unfortunately, isn't there and doesn't always cover full costs.
That's great. So thanks for giving kind of the definition of that, or framing that. Can you highlight maybe some planning tools? The phrase life estate gets thrown around, here and there, and I think most people don't understand that. A little bit on kind of Medicaid and how things have evolved over the course of time, and we hope that that's not a concern for a lot of folks. But we realize in the sandwich generation, we have some people who are caring for parents who maybe didn't have the same financial success, and so those things actually are real concerns. So I'd love to just have you kind of focus on the belly of the slide here.
Sure. So first point I want to direct you to is the program that really pays is Medicaid, not Medicare. Medicare, if you want to think of it in this frame, if Medicare is really akin to health insurance. There are other programs within it, but for the most part, it relates to your health and a health situation. Medicaid is different. Medicaid is a larger program. It can pay for health insurance, but a lot of people utilize Medicaid for custodial forms of care. So that when I say custodial, I mean you can't perform what I call activities of daily living. You can't independently bathe. You cannot walk properly, you need assistance. You need assistance, what we call transferring, getting from, let's say, a chair to a bed, or from out of the chair to get to another part of a room. If you have cognitive problems, so you have, unfortunately, have dementia and you are mixed up about everything in life, you have a major, like, you don't even have to go through the activity of daily living analysis. You have problems toileting, doesn't mean that that you're completely incontinent, but sometimes people cannot get to the facilities in time, or they need assistance getting to them. So that's kind of the Medicaid where they come in, where you need the aides at home, or you need to be in assisted living, or you need to be in a memory care unit, or in a skilled nursing facility. So Medicaid is the program. Medicaid is means tested. Medicaid is also a very interesting program because it's jointly administered by the federal government and the state, by each state. So the laws that we have, for example, in New Jersey, probably differ from the laws in Colorado with respect to certain aspects of Medicaid. Not the big, like, we have this thing they call a 5-year look back, that if you want to transfer assets because you're trying to eventually obtain Medicaid coverage, you have a 5-year period of time from the date you apply for Medicaid, that if you made a transfer, they penalize you. That's an overarching federal rule. The only state that does not participate in that right now is California. But that's something you're going to find uniformly throughout the country. However, there are little quirks in each state that differ. So New Jersey, we're a very tough state. We don't have a lot of various planning opportunities available. For example, we don't have something called spousal refusal, where a spouse does have an opportunity to say, I'm not using my assets to pay for my spouse. New York has that, but we do not. So you have to really be careful, because you'll read things online and they'll talk about different planning techniques that you just can't use. Jeff raised something with life estates. He asked me before the seminar, Peggy, do people use these anymore? I remember hearing about it, and I said, heck, I'm using that planning technique every day, and you'll say, what is a life estate? A life estate is, you own it, let's say you own a real estate, just a parcel, a house and a lot. You have what we call a fee simple interest. You own that house, but you can divide your title into 2 pieces. And it used to be done quite a bit, let's say in the 19th century, where you give somebody the right to the use and possession of that property for the rest of their life. And then there's what we call a remainder interest. Who does that property go to when that life tenant dies? That is a form of ownership, a title called a life estate with a remainder interest. And why do we like life estates in New Jersey? We like them because we have a regulation that says if you have a life estate, if you transfer title, reserve a life estate to live in a property and convey it, let's say, to your children or to a trust, 5 years goes past. You do it today is June 27th. You get to June 27th or June 28th, let's say, of 2028. Medicaid will not, in New Jersey, will not penalize you for that transfer, nor will they come after that property if you do receive Medicaid benefits and put a lien against that and try to retrieve the value of that property after you die, you, the Medicaid recipient. That is New Jersey. I don't know if that's the case in Colorado, and I know there are other states where you cannot do this, but it is a tried and true, accepted planning opportunity in New Jersey, and a lot of people take advantage of it. There are other things you can do. You can, and this is all about, why am I talking about all this? Because in order to qualify for Medicaid in New Jersey, you have to be down to $2,000 of assets. If you're married, they let your spouse, they'll say, yeah, the recipient has to have $2,000 and we'll let the spouse keep their home, a car, and half of all other assets, but the cap is roughly $139,000. So people look at that and say, well, what's going to happen to my vacation home? And I'll say, hey, that's got to count as, that's not your primary residence. That's going to count as part of your half of 100 and or $139,000. What about my IRA and my 401k? Well, in New Jersey, you're going to have to spend that all down. We don't protect it at all. There are states that do. So then Peggy Nee becomes a very popular attorney in the area because people say, I've got to do something. Either my colleagues will say, I don't do this kind of work. I'm a, pure estate planner. I need to, help. We need help here. And what we do is we try to come up with strategies to lessen all the spending that will have to happen in connection with care. Now, there are people who philosophically over the years have been opposed to it. And what happens is sometimes when they've spent, $500,000 to $1 million on care, their feelings change. And I've seen quite a bit of that. So what do I try to do? I give them strategies. How can the quicker we can get on, the better. I used to be able to get people on Medicaid very quickly back when we had a 3-year look back, and we had a different way of calculating penalties for gifts. And little tip for all of you. You'll hear, well, I can give away $17,000 a year. There's no gift involved. There's no problem. I do it all the time. Yeah, for gift tax rules, but not for Medicaid. Medicaid penalizes all gifts. Those are no-nos. So got to be careful. You start thinking this way, you have to consult with an elder law attorney who understands how the system works. People do things, they make outright transfers. They say, I'm going to go for it, 5 years. Let's do it. Let's move as much as we can. But it's not always so simple to do that. You might have children with, marital issues, special needs. So trusts come into the picture. By the way, in New Jersey, we cannot create a trust where the person who creates the trust retains an interest in it. Other states you can. New York, you can do it. You can do an income-only trust. Doesn't work here. You do that, you're still subject to a 5-year look-back period. Plus, the state comes after what's ever in that trust when your income, the person who created it kept the income. When that person dies, state comes in, says we're imposing our Medicaid lien. So really important to understand the various laws out there. Jurisdiction shopping happens. It's okay to do. You could say, I've got it all the time. I'm a New Jersey person, Bergen County. I live right near the famous George Washington Bridge. And I have people that we say, I can't do much for you in New Jersey, but boy, you move over to New York, we can do, well, not me. I'm licensed, but I don't practice elder law in New York, but I got a lot of friends in New York that are great elder law attorneys. We send them over and they can really preserve a lot of assets. So we do have people who move state to state because the state that you enter care into, you enter into a skilled nursing facility, assisted living, that's where you make that application. That state's law applies. So that's kind of a very broad overview, but very
It's
important.
like a master class. No, look, I mean, I'm like, and I've seen a lot of this stuff and talk to attorneys about it. And again, every time I just marvel at it. So anyone trying to do it yourself in the world of elder care planning, to me, is it needs to have their head examined. So again, thank you for that, and you can appreciate why it's important to bring in somebody who's truly an expert in the field. So I'll hit on this quickly. I do want to get to Alex to spend some time on some of the sophisticated trusts you were talking about a minute ago. But revocable trust, living trust, kind of see that a lot in our practice. it's become, really, really a popular tool. And as you alluded to, it's not necessarily about probate for everybody. Sometimes it is, especially for those folks who have houses in multiple states. But we really talk about, the element of benefiting from privacy, but really control or a much more thoughtful set of guardrails after we're gone. So again, I think the idea of hearing the word trust, sometimes it has the hair on the back of people's necks stand up. Other times, they're much more willing to embrace the concept of trust. But really, revocable trust, add a tremendous amount of flexibility to the planning discussion. And what's really appealing is just their flexibility, right? Revocable implies that again, they can be easily amended, restated, and whatnot. And we really want to impress upon people where that can make a lot of sense, even if probate might not be the boogeyman in New Jersey, whereas in other states it can be. So let's maybe spend some time on some additional more complex topics within the realm of trust planning. Maddie, you want to just go ahead and hop to the next slide?
Alex, we hear a lot about, different trusts, and Jeff just alluded to the difference between revocable and irrevocable. Can you sort of take us through briefly through this list on, and a lot of times people want to maintain that flexibility and they want to have access to the income of the trust. They don't necessarily want to feel like they're giving up their assets. So what are different ways that people may be able to do a little bit of both? Oh, you're on mute.
Muted. Let me unmute myself. Sorry. So yeah, we'll talk a little bit more about what I think is sort of the best trust for handling those two elements. Retaining some control over the assets and the income. And I guess before I jump into that, I think it's always kind of helpful to understand what a trust is. I think a lot of people think of it as like a thing. You hear about antitrust laws or trust busting. But I mean, really at its core, what it is a legal relationship, right? So the person who has the property, known as the settlor or the grantor, I've heard it called the trustor. I use the word grantor, so that's the term I'll use, gives assets to a trustee to take care of for the benefit of the beneficiaries, right? And so when you do that, you create these different legal relationships, and these legal relationships are can be taxed differently. And that in many ways depends on the level of control that the grantor, retains over the trust, the powers and the rights that you have within that relationship. So, just kind of going down the list, a common trust that sometimes that you'll see, this can often be created either at lifetime or through a revocable trust. It's just a descendants trust, right? Placing assets in trust to benefit your children, grandchildren. Depending on the state, these trusts can last a long time. In Colorado, a trust can last for 1,000 years. In states like Delaware, I think it can last almost forever. So that's one example. Another thing that we see quite often is what's called an irrevocable life insurance trust, or you hear that often called an ILIT. That can be a very useful strategy because you're creating a trust and you give it, you gift it some seed money, and the trust goes out and buys life insurance, buys a policy on either your life or a joint policy, like what we call a second to die policy. And then when that policy pays out, if the trust has been structured correctly, all of those insurance proceeds are not going to be, that death benefit's not going to be subject to transfer tax. Other sort of options that I've done before, although not much recently because of interest rates, is the grantor retained annuity trust. So that's where you as the grantor give assets to the trust, but you receive an annuity for the term of the trust. The remainder will go to your designated beneficiaries. That can be especially effective when you have assets like stock in a closely held company, for example, that you anticipate will appreciate at a great amount over a longer period of time. And then also we have charitable trusts, same sort of idea. we can help move assets out of your estate while also benefiting charity. So those can also be effective depending on the need. And then finally, these are very popular, what we call a lifetime gifting trust. So you might have heard that, you know, you can give up to, it's currently $17,000 per year to individuals. So like you can give your children or your grandchildren $17,000 each, $34,000 for a married couple. But usually you can't make that gift to a trust. So a lifetime gifting trust, I won't get into the details, but that's essentially a way for you to use that annual exclusion amount to put assets in a trust.
And so we talked also a lot about, you know, being aware of your state specific probate processes. You know, these are some of our most popular states here. You know, Alex, can you take us through Colorado, and then, you know, Peggy will have you sort of, you know, highlight New York and New Jersey, and we can touch on Florida.
Yeah, sure. I mean, for Colorado, I guess I didn't think that Colorado would have a lot in common with New Jersey, but I guess it does, in the sense that this is also a state that is very simple in terms of the probate process. It's a very small fee to start. The laws are very favorable, and it's usually relatively a painless process. I know that a lot of attorneys or a lot of clients will sometimes ask, you know, do I need to fund my revocable trust during my lifetime? And almost exclusively, I'll say, if all of your assets are in Colorado, no, you don't. You know, if you have property that's in another state, like Arizona or California, yes, we do want to put that in a revocable trust. But as far as your Colorado assets, things like that, there's really no probate need, avoidance need to do that in Colorado. And this is not necessarily related to probate, but this is, you know, something that we'll touch on a little later when we talk about blended families and couples who plan separately. You know, something to know about Colorado, and I don't know about New Jersey or New York or other states, but you know, something to keep in mind is how these inheritance laws work. You know, we've talked about how, well, what happens if you don't have a will? Well, if you don't have a will, the state basically steps in and decides for you who's going to get your assets. And so then the next sort of thought is, oh, well, if I have a will, then the state doesn't get to decide how I give away my assets. And that's not necessarily true, right? So for Colorado, yes, you can disinherit your children. I get that request a lot. In terms of, though, of a spouse, though, some spouses will have what's called an elective share, or, you know, an omitted spouse share. It depends on the terminology. So what that means is that regardless of what is in an estate plan, the surviving spouse has a right to a certain amount of assets. So in Colorado, you essentially take the decedent's entire probate estate, you add some other transfers in, and then you divide that in half. The surviving spouse gets a percentage of that based on the length of the marriage. So if the marriage is 10 years or longer, the spouse gets 100% of that half. And then it decreases, you know, if they're married less than 10 years. So that's something to keep in mind is, you know, regardless of the type of planning you're doing, that is a right that a surviving spouse has, and it can only be waived, you know, it has to be waived. So if it's not waived, then it applies. So you might think that you're doing some sort of, you know, you might think that your plan is going to do one thing with the spousal elective share. It could be doing another.
Thanks, Alex. That's interesting. Peggy, I know I heard a collective sigh of relief from a lot of clients in New Jersey back in 2016 when they you know, raised the exemption from 675 to 2 million, and then it subsequently, I think, went away in 2018. So I think there's like this collective like high fiving. So, but can you give us a little bit more substance there? Because I know it's not that easy. It's kind of a, hey, not so fast for certain families. So again, if you could take us through some of the specifics that make New Jersey a bit unique in that respect, I'd welcome that.
Well, yes, we did. We had a New Jersey estate tax. It was very similar. There was a way, what happened was we used to have a tax, an estate tax, where we just charged people the credit they received, the state tax credit on the federal estate tax return. But when the federal estate tax, when the whole system became so different and you had much larger exemptions, the states were no longer, there was no longer a state death tax credit being generated. And New Jersey and other states were getting kind of hammered by this because they were relying on it for their budget. And the governor at the time went to a conference of governors, and one of the other states said, we're going to come up with this new system. And basically, under the new system, we ended up with a $675,000 New Jersey estate tax exemption and everything taxed over that, which was a killer, because many people were getting trapped into that. So a few years back, when Governor Christie was governor, they repealed the New Jersey estate tax. So you, as Jess said, collective sigh of relief. However, we have one of the worst taxes that you can have in the country. There's just really a small handful of states that have it. It's called an inheritance tax. The tax is determined by the relationship of the beneficiary to the person who passed away. So if I have a will, and in my will I say, you know, I have a spouse, I'm leaving everything to my spouse, and when my spouse dies, it goes to my children or my grandchildren. But I'm leaving, let's say I have a sister and I say, you know what? I'd like to leave some money to my sister. I'm going to leave her $30,000. And, you know, all great, well and great, but then my kids go and they try to start collecting assets, and these financial firms say, not so fast. We looked at the will, you gave it to us, and it says that your mom's or your wife's sister is entitled to $30,000. She's a non-Class A beneficiary. You have an inheritance tax situation. You have to file a return. Come back to us with a tax waiver. And my sister and my brother are considered Class C beneficiaries. That means that there is a $25,000 exemption against New Jersey inheritance tax, but anything they receive over that is taxed at 11 to 12%. So, and what about my nieces and nephews? They're Class D beneficiaries. So they're no different than if I left all my money to Jeff. He's not related to me. If I left it to him, he's a Class D beneficiary. 15 to 16% tax on anything you leave a person over $500. So you're talking, you can rack up a huge tax very quickly in New Jersey. And it's unfortunately, I mean, there's no getting around it. If you're a resident of New Jersey, when you die and you leave anything to anybody who is not your Class A beneficiary, who is defined as your parents, your spouse, or your lineal descendants, so that's children, grandchildren, great-grandchildren, they're Class A. You go beyond that, you have to look at inheritance tax. Now, charitable organizations are Class C. They are not taxed, but you still have to file a return. It's ridiculous, but you have to do it if there's Class C beneficiaries involved. So unfortunately, not a good thing. I just want to comment too on Alex, the contrast between the, like we call spousal share, elective share. One other kind of interesting thing about New Jersey, I can't say it's good or bad. Our law on that, you know, whether a forced share for a spouse, it is based on the 1969 Uniform Probate Code. It is very easy in New Jersey to defeat that forced share of the estate. And the forced share is something called, you get 1/3 of the augmented estate, and the 1/3, so if let's say man dies, he has $3 million, survived by spouse, he completely disinherits his spouse. The spouse would be entitled to $1 million. We'll just make it simplistic. It's $1 million, right? If that surviving spouse has her own assets, so she has her own $1 million, she gets nothing, zero. That is the scheme of our fourth share elective share statute in New Jersey. Why? Because it's based on a super old provision of the law. So that's a kind of a significant difference.
Thanks, Peggy. I know I can speak to a little bit of this. I used the phrase jurisdiction shopping earlier. So New Jersey is a great place if you have a Brady Bunch family in the sense of lots of kids and grandkids to leave money to. But New York is not necessarily a great place if you have a sizable state, independent of your the kind of family tree, right? The exemption today is much lower than the federal government. Not to say that $6.58 million is low, but for those high net worth clients, we've seen them move from New York to New Jersey, assuming again they're talking about leave money to kids and grandkids. I know Florida is oftentimes perceived as this Shangri-La for retirement, especially today with the pickleball games. But can you give us a couple talking points, Peggy, on your experience in Florida? I know you passed the bar there and you can practice in the state.
Yeah, Florida, there's a couple of Shangri-La aspects to Florida. One is there is no state income tax. Contrast that to New Jersey, we do have a state income tax, and one of our really bad things here is we do not have a capital gains tax rate. We've lost some significant taxpayers to states like Florida because of that. They anticipate selling an asset that has a lot of built-in gain. They don't want to pay, let's say it's not real estate, just for simplicity. They relocate to Florida and they avoid all state income tax. What's not a Shangri-La about Florida? And oh, by the way, there's no estate tax down in Florida, and there is no inheritance tax. One of the bad things about Florida is the probate system, because you have a full-blown court proceeding and you're in a circuit court in front of a judge, and you are required to, you can't make a move without a court order. You can't go to a safe deposit box and open it. You can't remove anything out of the box without another order. You're in court constantly reporting on what's happening with assets, even out of state assets. It is a process. So what people do is, to avoid their families going through that or their loved ones, they will create these revocable trusts, but they have to transfer the title to their assets to that trust in order to avoid the probate system down there. So you really have to, if you're going to do that, if you're going to become a Florida resident, you really have to be careful. Well, first of all, you have to be careful about establishing residency, which isn't so easy as you might think. You really have to think about it in terms of, what would I do if I were actually moving somewhere permanently? I'd change my driver's license. I'd give up my safety deposit box and the place I lived. I would register my cars in this new state. You have to do all those things. People try to play games. The government of the state where you are leaving is hip to this, like New Jersey and New York particularly. They will subpoena your phone records, your cell phone records. They will look at your E-ZPass activity. You gotta really be all in and be there for more than, you have to be out of the state you're leaving for more than 180 days. That's the key thing. But yes, it is, Florida has its advantages, but that probate part is real disadvantage. And this whole, the New York thing, I will tell you that we have had people, not only for Medicaid purposes, but to avoid the New Jersey inheritance tax, they'll say, you know what, I'll take my risk that I'm going to, about the 6.58 million exemption. I'd rather take my risk, go over to New York and establish residency to avoid the New Jersey inheritance tax, which I know is hitting my beneficiaries from $1.
Sounds good. Thanks, Peggy.
So next, we're going to be talking about estate planning strategies and considerations for not only this year, but there are some big changes coming down the pike possibly in 2025. So we're going to hit on those as well. So we're going to be talking about federal estate tax, portability, potential sunset rule changes, some possible complex trusts, and then some blended family considerations. A lot to get through in 6 minutes. We may or may not be able to do it. But Alex, can you talk to us about what are the current federal transfer taxes? You're on mute.
Unmute myself. Sure. So I like to call these transfer taxes. I think a lot of people hear like estate tax or death taxes. Really what's going on is a tax on the transfer of assets from your estate to the beneficiaries. And there's, in a sense, there's three. Two are sort of joined together, and I guess I'll explain that. And I think on some level, it's sort of helpful to think about how these taxes came about. So, first there was no estate tax, right? You could leave as much as you wanted to anybody tax-free. And then they instituted a estate tax. And so then the idea was, oh, I'll just give away all my stuff right before I pass away, and then I won't have to pay the estate tax. So that's where we got the gift tax. So now those are linked. So there is a tax on assets that you give away during your lifetime and at death. And they're linked in the sense that they have the same tax rate and the same exemption amount, which we'll talk about. So we have these taxes, and then the idea then was, okay, if I don't want to give assets to my kids because then they'll pay the estate tax. Like I'll pay the estate tax, then my kids will pay the estate tax. So I'll just give stuff directly to my grandchildren. So then they institute the generation skipping transfer tax, or what they call the GST tax. So that is a tax that's in addition to the estate and gift tax, but it only occurs when you essentially skip a generation. So for example, grandparents leaving assets to grandchildren. So the tax rate for both of these is 40%, and they each have an exemption. So that's essentially an amount that you can give away without being subject to either of these taxes. And for both of them, it's currently $12.92 million.
And what are some exclusions for those taxes?
Yeah, that's a good question. So there's no GST or gift or estate tax on most transfers to spouses. So like if I give my wife, I don't know, right now we in our house as joint tenants. If I give my half of my house to my wife, there's no gift tax on that. If I leave all my assets at my death to my wife, there's no gift tax on that, or estate tax on that, or GST tax. The other sort of big thing that we've talked about previously is the annual exclusion amount, right? So if so my parents, for example, could give $17,000 a year to my children without having to pay any kind of tax. And then there's this lifetime exemption that I've mentioned too, which is currently $12.92 million. So that's sort of the number, like as estate planners, that's sort of the big number. That's the number that we have to sort of play around with and make sure that if we can use it now, if we can use it smartly, we can avoid these taxes in the future.
And we talk a lot with our clients, this is, we do this in the sense of estate planning as well. Can we talk about, some federal transfer taxes and what is the significance of basis and the significance of a step up in basis?
Sure. So the US is actually pretty unique in the sense that for capital gains tax purposes, if you receive an inherited asset, that asset is adjusted to whatever its fair market value is on the date of the person's death. So we have the example here. You buy a share of stock for $20 and you hold it until you pass away. If it's included in your estate, then its basis is adjusted to $100. So theoretically, if it's sold a day or two later, you can almost entirely avoid capital gains taxes. And I also just kind of want to emphasize, a lot of times clients will hear this as a step up in basis, as in the basis is, getting increased. I sometimes use that term too, but I think it's better to think of as a basis adjustment because the basis could go down, right? It's whatever the fair market value is. So that's also something else to keep in mind when we're planning.
Mhm. Especially as you talked about before, if we have someone who's working for a big company that's been given a lot of stock that may have a low basis and it's sort of accumulated in their estate, that inheritors are going to get a step up in basis.
Right. Or, I have clients who have, or I've worked with clients who have like ranches, for example, that they've depreciated. If they hold it until they pass away, right, we avoid that depreciation recapture because the adjustment is to fair market value. And talking about this, looking at this next slide, I think something that's important to note is, had this estate tax had exemption, it was always fairly low, and then it got a big boost.
What was it
27.
before the Tax Cuts and Jobs Act? Do you remember?
I mean, that was sort of before I started practicing, but I mean, I know that like during the like George W. Bush years, I want to say it was like under $1 million. Peggy, does that sound accurate?
Prior to George W. Bush, it was actually for years $600,000.
Oh, wow.
Yeah.
And then it went to $1 million. So that was the first up. And then it went to 3 million and it kind of went up from there. But yeah, it was 600,000. I mean, I had people sit and cry when they had to write checks out because the rate of tax is the killer. It was,
Yep.
at that time it was 50%.
Yeah. So we had the passage of the Tax Cuts and Jobs Act. It increased the amount to 11 points. I had it on one of the slides. Hold on, I don't see it in front of me.
It's like 11.49.
Yeah, it was something like 11.49, and that was an increase over what it was at the time, which was 5.49. So we have this big increase, and I think something to keep in mind too with the estate tax is the rate has never gone down. I mean, it stayed stable for a while, but it's always gone up. And so now what we're looking at is a moment where the estate tax might actually decrease. Because when they passed the Tax Cuts and Jobs Act, I don't want to get too far into the weeds, but it was a budget reconciliation. So a lot of these provisions were sunsetted. So essentially what's going to happen is if there's no new legislation on January 1st, 2026, the exemption amounts will revert back to 5.49 million adjusted for inflation. So we'll say like $7 million. So if we're using like today's values, that's a decrease of about $5.92 million.
And we hear a lot about portability, this idea about portability. So can you talk to us about exactly what that is, who can use it? And then in the next slide, we'll go into some strategies.
Sure. So portability is this idea that if the deceased spouse does not use all of their gift and estate tax exemption, they can pass it on to the surviving spouse through what is called a portability election. And as this is something that's relatively new. And if the exemption goes down, that's going to be something that is extremely important. We can use the example of a spouse that passes away, tomorrow. If they leave everything to their surviving spouse, they will have $12.92 million of exemption that they can give to the surviving spouse. So even if a reduction occurs in the future, the surviving spouse will still have that $12.92 million. The thing to keep in mind, though, with the portability election is you have to make it on a timely filed estate tax return. So normally a return is due 9 months after the date of death. You can file for a 6-month extension. So that's normally when you have to do it. There are certain exceptions, though. So if the estate wasn't required to file a return, so let's say that the estate is below the $12.92 million threshold, there's a procedure that you can use that allows you to file a return up to 5 years late to claim that, to make that portability election.
And so what are some strategies, if the exemption does go down from, the 12 million to possibly 7 million. What are some strategies for using the exemption?
Could we go to the slide on slats? I think we might have to skip ahead a little bit.
Yep.
Okay. So the big thing that I've been doing for the past couple of years for a lot of clients are what's called a spousal lifetime access trust. And the reason that we're doing that is the IRS has said that if you use your exemption before there's a reduction, they're not going to try to claw it back. So like if you use all 12.92 million and there is a sunset, they're not going to say, well, we're going to take back, 5.92 million. So the goal now is to try to lock in this exemption while it's higher. And I think the best strategy for doing that is what's called a spousal lifetime access trust. So that is a trust where one spouse makes a gift to a trust that benefits the other spouse and their descendants. And the reason why we like to do that is that locks in the exemption, because that does use exemption, but it's also not really removing the assets from the family balance sheet, right? Because the spouse who's the beneficiary can continue taking distributions from this trust. So we're really not removing those assets from the family's estate. The other, nice thing about a SLAT is it's what's called a grantor trust. And what that means is that the tax laws create the person who creates it, the grantor, and the trust as the same taxpayer. And you might be thinking, well, hey, why would I want to pay my trust taxes, right? I'm not a beneficiary. There's a few reasons for that. One, a trusts and estates pay the same rates as individuals do in terms of taxes, but the brackets are much more compressed. So you're getting into that high level bracket at, I think, around like $14,000 of income. If the grantor is paying the taxes, though, that's allowing the assets in that trust to grow tax-free. That's one thing. The other is if you're going to have a taxable estate, when you make these income tax payments, that's essentially another tax, or at least another estate income tax-free gift to the trust. So we're reducing your taxable estate by doing that. And then finally, in terms of moving assets, you can do sales to a grantor trust without capital gains taxes. And again, the logic of that is the trust and the taxpayer are the same person, so it's not like a real sale. So we can sort of get creative in doing discounts for businesses, properties, things like that, and again, potentially move more assets out of the taxable estate.
And with anything, life is a game of trade-offs. What are the trade-offs, that you would be making if you, implemented a SLAT?
Right. And so the thing to keep in mind with a SLAT is if the beneficiary spouse dies before the spouse that's the settlor spouse is losing access to those assets. So, if you're sort of relying on if you're sort of relying on the settlor having access to those assets, that might not always happen. The other thing is, as long as the spouse is alive, the beneficiary spouse, the grantor spouse will have to pay those income taxes. There's really no way around it. You can, at least in Colorado, you can do like income tax reimbursements, but you can't always rely on that. If you're always getting reimbursed, then the IRS starts to think, well, maybe this isn't, a real trust, relationship. Something else that I will hear about, or that I hear from clients, is like, oh, Alex, this is great. I'll make a SLAT for my wife, and then she'll make a SLAT for me. Perfect, right? Well, no, not really. There's what the IRS calls the reciprocal trust doctrine. So if you do SLATs too close together, or you're using similar assets, or they're similar trusts, they're going to unwind those and say that really it's still in your taxable estate. So it's really kind of important to coordinate this type of planning with a SLAT. The other thing that sometimes you run into is the family saying, oh, we have this great property, let's put it in the SLAT. that really doesn't tend to work because you have to keep in mind that the grantor spouse is not a beneficiary. So if they're using the property that's in the trust, they really shouldn't be. So they have to either pay rent or, not use the property. So I usually tend to recommend you don't put real estate in a slat. And then sort of the final thing to keep in mind is, I don't know, Peggy, if you've ever gotten an answer to this question. I know that I haven't. Like, what happens to an outstanding promissory note on the death of the grantor? But it's sort of like this tax mystery. So sometimes when we do these sales, it's usually in exchange for a promissory note. Sometimes, or at least there are some commentators that say, if the trust terminates at the grantor's death, you could have some capital gains issues. So it's usually, if you do these sales for a promissory note, we do tend to try to recommend that you pay them off before death.
Yeah, you have to be careful also about what they call OID and income where someone is foregoing a payment. You think, well, okay, they're not getting a payment of interest. Well, if you don't get a payment of interest, they can come in and say, you've got a forgiveness of indebtedness income, which is horrible. And the IRS loves to pick on that. And so there's all these different, you really have to be careful with the promissory notes. But it's a big planning concept that people are using on a national basis. And there's all kinds of different uses these days of notes and lending, and this is one of them, the slat with the slat.
And we did want to we touch on marital trusts. We hear about them a lot. What are they and why are they important?
Sure. So and in terms of time, just let me know if you ever, if you need to like cut my mic, if like this is the Oscars, just let me know.
So we won't play any music. We appreciate taking the time, guys.
Okay. So as we talked about before, there's this unlimited spousal deduction that's available for the gift and the estate tax, and normally that doesn't apply to gifts that you make in trust. However, there are some exceptions. So the big one is, you'll hear it often called a marital trust, or sometimes you'll hear it called a Q-tip trust, which is a qualified terminal interest property trust. And that's a strategy that we use, and this can especially be effective for blended families, where you can leave the assets in a trust for the surviving spouse, and the surviving spouse is entitled to all of the income from the trust. But at the termination of the trust, you can distribute the remaining assets to, really anyone you want, usually your children. So that can be something, as I said earlier, for blended families, where you provide for the surviving spouse during his or her lifetime, and then the remaining assets can go to the children of the deceased spouse, for example. Another sort of good thing about a marital trust is it is includable in the surviving spouse's estate. So that can also be good for getting that basis adjustment that we talked about earlier. Putting certain assets in there to get that to happen.
And then, finally, what are some key takeaways for, more federal estate planning as that exemption may sunset in 2025?
So I think the key takeaway is, if you're looking at your balance sheet and you're thinking, okay, well, I don't have, $25.84 million of assets. If the sunset goes down to let's say it's 7 million, and you and your spouse have an estate of around 10, 12 million, you can certainly plan now if you want to, but you have to keep in mind that if you have that exemption amount and you're not going to pay estate tax, you need to keep in mind what we talked about with income tax planning, basis planning, right? Because something that I don't think that I mentioned earlier is, if you put assets into an irrevocable trust during your lifetime, they don't get a basis adjustment. So if you can avoid estate tax because you have enough exemption, then, really it's the focus is on income tax planning. If you're looking at, your balance sheet and saying, well, hey, if this exemption amount goes down, I could be looking at a taxable estate. Then I think the important thing is to have these conversations with a planner and, look into something like a SLAT, for example. Look at ways that you can lock in your exemption before it goes down, and sort of ensure, plan now to avoid these estate taxes later.
Great. Yeah, I
And
think,
then,
go ahead, Maddie, please.
no, I was just going to say the last slide we had here was, maybe just some specific considerations for blended families or maybe couples or partners who plan separately from one another.
Yeah, sure. I'll try not to take too long because I know that we've gone over. I would say like the first thing for blended families or families that plan separately is honesty. You have to be honest with each other about what you want to happen. Sort of planning in the dark or putting it off. Just it never works out. Trust me. The other thing is coordination. As Peggy talked about earlier with beneficiary designations, if those aren't aligned with how you want your plan to work, then that sort of defeats the whole sort of purpose, right, of this planning. Especially if you say, oh, well, I'll just, leave certain assets to my spouse and I'll leave certain assets to my kids. And you sort of have this plan in your head, but you don't coordinate with the beneficiary designations, and that kind of all falls apart. The other thing that I will say too that's important about planning is commitment. I think that something that you see a lot of is we talk about a plan, people get used to it or getting ready to execute the documents, and then a long period goes by where nothing happens, or this sort of, I think, constant, rethinking of very minor elements of the plan. I mean, I think it's just really important with your estate planning attorney, all your other professionals to just be like, look, this is what we want. And, there's a million different things that can happen, but we've made a good plan. We've nominated people to the important positions that we trust, and we're just, we're going to follow through with this. And then the other thing is, obviously, once you've made a plan, you need to continue to review it. I usually tell clients to try to take a look at their plan every, 2 to 3 years, unless something significant has happened. For example, a change in the family's wealth, a closely held business or a family-owned business just really takes off, or they receive a large inheritance from their parents, things like that. Those are always good times to review the plan, and also too when changes happen in the family, right? Like a remarriage, or a child marrying a spouse that maybe you don't like. That can happen sometimes too. So yeah, those are, I think, all things to keep in mind. And then the other thing to kind of finish up for blended families, the marital trust, I think, can be a very effective way of providing for one spouse during his or her lifetime, and then, children from the blended family afterwards. Some states like Colorado, I haven't really done this too often, but some states like Colorado do make what's called a contract to will. So you can sign a binding contract that says, this is how I'm going to leave my estate. And so I think sometimes families like that because it just makes sure that everybody's on the same page and will follow through with whatever the estate plan is going to be. And then I know we're running out of time, so I'll try to make this as simple as I can. Another thing that's good for families is what's called a power of appointment. And so that's something you place in a trust agreement. So we'll use the example of the marital trust for a blended family. Let's say that spouse A creates the marital trust for spouse B and says spouse B has a power of appointment over the trust assets. That means that she can direct the assets to a certain class of beneficiaries. And let's say that class is, their children. So, spouse B might or sorry, let me start over. So we can say that like half the assets of that trust would go to spouse A's children, his or her children from a prior marriage, and then spouse B gets a power of appointment over the other half. She can give that property to her children however she sees fit. Even if you don't have a blended family, a power of appointment can be good just because it can help plan for things that you couldn't anticipate when you initially made the plan. So, again, to go back to the marital trust, let's say that we don't have a blended family, we have 4 kids. The spouse has this power of appointment that she can use to direct the assets of the trust when she dies. And let's say one child's done very, very well, doesn't really need the money, and the other children do. The surviving spouse can say, okay, instead of, a fourth, a fourth, a fourth, I'm going to do, 1/3 to the 3 children who need the money. So that can also be useful. That can also be a useful planning tool.
Thank you. And just to, a sort of reiterate what Alex said before, some final thoughts here. A, just make an estate plan. B, implement that estate plan. A lot of times we see, that people haven't actually moved anything into the trust. And I know, maybe in Colorado, it's a little bit easier, but, we want to make sure that people are implementing the plans that they paid for. And, we revisit these plans when there's tax law changes, when you have a big life event, and there's a time consideration piece there, especially as laws change.
That's great. Let's just go ahead and take a look at the queue here. So what we'll do, just in the spirit of time, some of these questions look like they might be a bit on the personal side. We'll thank our guests for their time. Ultimately, this is time they might be normally meeting with their clients and billing. So Peggy and Alex, thank you so much for your time this afternoon, and obviously the preparation leading up to this. Folks, we have sought feedback in our prior webinars. We do it somewhat informally, not asking you to fill out a survey, but if you would find it, we would find it helpful if you felt compelled to, share in a note, some of the key learnings, things you took away from the discussion, or suggestions for our next event. I would ask you again to keep your calendar open. At some point middle of July, we'll do our Q2 market update, give you a little bit of a recap of what's happened the first half of the year, and the outlook for what we see on tap for the remainder of 2023. So again, thank you so much for your time today, and again, we hope this really was a good experience, and you're able to learn a couple of things from some true experts. Thank you so much.
Thank you.